hearing is convened to adjudicate the elector challenge by Margaret A. Boodle of Dr. James H. Burnham to remain on the Camden County list of electors. Georgia Code 21-214 Foxtrot requires that this and all hearings be conducted in public. I'm Kyle Rapp, the chair of the board and the presiding officer. I have with me Barbara Hahn, Claire Harden, who is our vice chair, Kelly Toffler, who's a board member, and Julie McCullough, who's also a board member of the Board of Election and Registration. Is the challenger here? All right. Is the challenge voter here? All right. Here's the process of the hearing. Per Georgia Rules and Regulation, Rule 295-11-02, all testimony given at this hearing shall be under oath. The oath shall be administered by Shannon Nettles. And per 21-2, Rules of evidence will be in accordance with 21-1-24. In accordance with the 21-2-29, the burden shall be on the elector making the challenge to prove that the person being challenged is not qualified to remain on the elector's list. And here's the order of presentation. The challenger shall present their evidence. The challenged voter is allowed to cross-examine. Once he is done, the board will have an opportunity to cross-examine also. Do you have any other witnesses with you? Okay. So that'll be the challenged voter. If he decides to make a statement, he will have his opportunity. You'll have an opportunity to cross-examine. We'll cross-examine, and then we'll adjourn the meeting. Any questions? All right. With that said, Ms. Shannon, can you oath or swear in Ms. Boodle?
If you could stand, please. Do you solemnly swear that you will tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury, so help you God? Thank you.
Please step to the podium if you plan on making a statement or providing any additional
You don't have my information, but I'd like to introduce myself. My name is Margaret Butel. I've lived in Camden County since January 25th, 2020.
Can you move the microphone up?
Oh, I'm sorry, I got used to it. The first thing I did when I moved here was to register my cars and to register for voting. And I immediately applied to be a poll worker. Voting is very, very important to me, as I'm sure it's to everyone else. And I'm just, as the secretary of the Republican Party, I received a letter of ex officio member, and I felt it was my duty to investigate, and that's what I did. And you have all the paperwork in front of you. And if you have any questions for me, I think it was pretty clear what I did. I didn't go back a third time because I was told that I was harassing someone by knocking on their door. And from this evidence, since I never saw Mr. Burnham, I concluded that he did not live at that residence.
Do you have anything else for the board?
No, that's it.
Can you remain there, Mr. Burnham? Do you have any cross-examination questions?
Not really. I don't think so. But was my application to the member of the board what prompted you to do this?
Yes, sir.
No one prompted.
No, sir. I did this on my own.
All right, any questions from the board? I do have a couple of questions.
Sure, sir.
When did you realize that Dr. Burnham, his name was on the deed to 204 Candy Court?
I had looked it up before I even went to the deed. That was just recently, because when I looked up in the tax records, his wife with her maiden name or her other married name, I don't know what it was on the deed. And then I knew that, so I knew that I thought that the place was then rented because Mr. Burnham's name wasn't on it. Apparently it was changed over to both their names. And then the mailing address was the vacant property at, on Osborne Road. And so I made some conclusions, but I wanted to further it because integrity in voting is very important to me. And I just want the truth. That's all I want is the truth.
Did you follow up with the tax assessor's office to make sure that?
Yes, I looked at the tax assessors, and it was, at that time, it was going to the Mrs. Burnham's house in Yulee. That's where the tax records were going.
So you actually spoke to the tax assessor?
No, I didn't speak to him. I just looked up the records.
Okay, so you did online?
Yes.
And the online records aren't updated as far as the ownership, but maybe twice a year.
Mhm.
Now, as far as the deeds are concerned, once they come into the tax assessor's office, they're uploaded immediately. So if you look on the tax assessors or the Q Public,
I did.
if you could bring that up, Ms. Kayla? Q Public?
I did bring that. Unfortunately, when I left the house, I had my paperwork on that thing and forgot it.
So if you could scroll down just a little bit. This is more that maybe a training thing. Keep scrolling. Okay, come back. All right, so this is what it looks like if you look it up on your phone.
Mhm.
You see where there's a columns radio tab over there on the right-hand side?
Mhm.
Normally, if you look it up on a PC, that all the columns will be filled. So if you look it up on your phone, that's all you're going to see.
No, I looked it up on my computer.
You looked it up on your computer, okay? Because normally all the columns are filled up, and you would see that when you pulled it up, wherever you pulled it up in September, you'd have seen that on 1/10/23, the deed was actually executed to put it in both their names.
Right. That was my mistake in saying that.
So just for future reference, make
Mhm.
sure that you look at everything,
I sure will.
and then follow up with the tax assessor office, and maybe even the clerk of course to see if there's a deed filed.
Right. Okay. Thank you.
Any other questions? You may be seated, ma'am.
Thank you.
Thank you. Mr. Burnham, do you have any testimony?
Yes.
Shannon, can you swear him in, please?
Do you solemnly swear that you will tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury, so help you God? Thank you.
Please come to the podium, state your name, and speak.
My name is James H. Burnham. I've lived in Camden County since 1977. I opened a business here, January 78. I was in that business for almost 43 years until 2019 when I had an eye surgery, which left me unable to see. So I had taken 10 days off from work to have the surgery done and never went back. Right after that surgery, well, let me go back. I first registered to vote on June the 17th, 1968. It was a very proud day for me. I got off of work that day. I was the first one to the time clock to punch out because I was on a mission. I was going to register to vote and to register for the draft. And I felt very proud. I wish I could instill in young people today the pride that I felt going to register to vote and also registering for the draft, even though I knew that I might get to go see Southeast Asia. As it turns out, I did not. But for the next 10 years, I never missed an election. I voted in Dodge County elections for the next 10 years. 2 of those years, I lived in Davenport, Iowa. I didn't move my voter registration because I knew where my home was. One of those years, I lived in St. Mary's, trying to get enough money to get back in school. One of those years, I lived in Atlanta, doing the same thing, working at JCPenney's catalog distribution. I never moved my voter registration until I got married and lived in Dodge County. I moved it 3 addresses down because the house that I was living in was 3 houses down from where my parents were. My wife was registered to vote in Chester, Georgia, which was also in Dodge County. Her father was a mayor there. But she moved her voter registration to our house. And whenever I went back to school again, we left our voter registration in Dodge County because we both knew where our home was. When I moved down here, even though I still had property in Dodge County, I knew I was never going to live there again. So I moved my voter registration here. Now, during the time that I was here, I've always used my office as my mailing address. The reason I do that is to avoid having people come to my door and knock on my door, bothering me about stuff I don't want to be bothered about. Now, during that time, I did have some incidents that made me really glad that I did that. During the 80s and the 90s, I was very active in the Republican Party. In fact, there was no Republican Party in Camden County until I organized it in 1984. It had been organized back in the 60s during the Nixon campaign, and my uncle was the chairman at that time. During the 1980 campaign for president, Jack Gross had organized it along with Charlie Smith Sr., not the junior, but his father. And a couple other people that worked at the telephone company had come together and had organized a party during the 1980 presidential campaign. Well, they never bothered to reorganize after that. So I reorganized, I think it was in 83. Now, during the 80s, twice my sign was damaged. Once by a gunshot that went all the way through it. My window at my office was shot one time. And then I had the sign damaged again by apparently a marble and a slingshot, I would assume. I found a marble inside when I disassembled the sign to get that repaired. That's some of the reasons that I prefer not to have my voting address, because I feel relatively sure that it was some of my political activity at the time, as the county was beginning to turn from blue to red, and somebody didn't like that, or they didn't like some of the letters that I used to write to the editor when I could see how to read and write. Now, during the time that I've lived here, my first residence was on Ann Street. I was registered there. Then I moved to Point Peter, and I registered there. And then I moved to Bristol. Well, then I moved to Coleraine Road. I lived there for a while. I continued to get my mail at 1836. Then I bought a house then I built a house. I already had the property, but I built a house in Bristol Hammock. During that time, I had to move my registration to Kingston. That was the only time I was not registered to vote in St. Mary's. But I still received my mail at my official address, 1836 Osborne Road. I still own that property. I still use that as a mailing address. It is not vacant. It is being rented by a subcontractor, a painting subcontractor. I have disconnected the power that was in my name there and the water that was in my name. It is now in the renter's name. But I still get mail there. But I also get mail mostly about official business at my home residence, 204 Candy Court, not 210 Candy Court as you wrote in the, and also there's no Osborne Avenue in St. Mary's. There's an Osborne Road and
Please
Osborne
address
Street.
the board. Please just address the board.
Okay, thank you. I'm sorry. But where was I? So that's some of the reasons that I do this. Now I'd like to show you some documentation. I'm visually impaired, so I really can't see.
Okay. So the board will take a look at the evidence and we'll hand it to the challenger so that she can also look at the evidence. Okay. Okay. I don't want to hold on to your driver's license, but it does say it expires in 2026, and it is from Candy 204 Candy Court.
Thank you.
Okay. Here's the assessors. Did I show it's in his name? It's old one.
Now, when the person that went,
Just a second. The information you gave us is old. From the tax assessor's office, it still shows just your wife's name in there. Do you have anything?
That was what came in the mail to us. We didn't.
Correct. Okay. Can you pull up Q Public again?
Sorry.
Just so that we can take a look at it and scroll all the way to the top. Okay. Can you go down where it says owner? All right. So this is the current Q Public, and it does show that James H. Burnham is the owner of it, and it was executed on a deed back in January of this year. Yes.
Okay, back to my voter registration. I was in a bad relationship at the time. When I moved back to St. Mary's, I moved to Magnolia Street. I lived there for a couple of years. Then I bought a house on Acorn Street. I lived there for a while. Then I moved to Palmetto Street and sold my house on Acorn Street. After my eye surgery in 2019, I decided I needed to remove myself from the relationship that I was in. So I moved into my office, which was vacant at the time because I could not practice. Well, I don't know exactly what the rules are for living in commercial property, but there was no business there. So I kind of kept that low profile because I didn't have any place else. My sister, and I was being visually impaired, I needed some assistance from time to time, and I have some extended family that would provide that. But my sister asked me to come stay with her, and I did that for about 2 years. It was after that period is when I married Nancy. Now, I still maintain my legal residence as 204 Candy Court. When I file my taxes, she and I file taxes separately. I file my taxes in Georgia, she files hers in Florida. I think we fought a war about taxation without representation. And I maintain that I am qualified as an elector based on all the evidence I presented. I have ownership of a home. I'm a resident there. I have 2 roommates there, and they were harassed. The first one, and the only reason I did not take out, or we did not take out a criminal trespass warrant is because Dustin, the first person she encountered.
So that's a separate matter as far as the criminal is concerned. We understand she went to the house, and can we move on from that?
Well, we can,
Okay.
but if she ever comes back again,
That's between you and her and not the board. Okay.
okay. So what questions might you have for me?
Do you intend to remain a Camden County resident?
I absolutely do.
Chairman Rappin, Mr. Burke, the only reason I bring this up is because this was information that was in the packet. The application for homestead exemption, it was dated in May of 23. It says that is any part of that property rented, talking about Osborne Street. That's a commercial property.
Actually, if you look in B, section B, it talks about 204 Candy Court. He put his mailing address on the top.
This one?
Yeah, on the top, and
Okay.
then Candy Court down in section B. I made that same mistake also when I first read it. But the homestead exemption is for 204 Candy Court.
Yeah, there's no homestead exemption on 1836 Osborne.
No, can't be.
Thank you for clarifying that. Okay.
So one of the rules for becoming or staying a resident or becoming a resident of Georgia is if you have a homestead exemption. Now, I understand this is just an application, it's not been approved yet,
That's
but
correct.
if you can prove that and this is between you and the tax assessor, it has
Yes.
to do with the board. You just have to prove that you live there.
Yes.
Okay. Any other questions for the board? Challenge, do you have any questions? You're allowed to crop.
Do you live in that house?
I do. I give the roommates a very good rent agreement because they're sharing it with me.
Don't live with your wife and you live.
Where I sleep is my business.
I just thought where you sleep is where you reside, and anyone can own property and rent it out and not be a resident.
You know, I recall that once, during the time that I've been here, I served as precinct chairman of the Harriet's Bluff precinct for almost 20 years. During that time, I made every effort to observe all the election laws as they applied. The only time I ever challenged electors was when I knew that these people were not living in Camden County, but Charleston County, but they were voting in both counties.
Are you registered to vote any other county or state other than Camden
I've
County?
never been registered to vote anywhere except Dodge County until 1977 and Camden County until today. And I hope we'll be tomorrow.
Is that all? Mr. Burnham, is that all?
Unless you have more questions.
Yeah, go ahead.
This reminds me of the movie Blazing Saddles. Now, the only reason this came about is because I wanted to continue to participate in the Republican committee, which I've participated in longer than anybody, because there was not one here until I started it. I have served on that committee for probably 40 years continuously in some office. Now, I understand that there is a new regime that doesn't always agree with me, and I've kind of made my reputation being disagreeable when I believe that I am correct and they're wrong. But this reminds me of Levon Little in Blazing Saddles pulling the gun on himself, because she's supposed to be a Republican who is supposed to be supporting growing the Republican Party in Camden County. Instead, she's out trying to remove legal electors from the list. I am going to start a petition to have her removed from the committee for cause.
Sir, that has nothing to do with this meeting today.
Okay.
We do have more questions from the board.
Mr. Burke, I just want to clarify one more time. Do you live in Yulee, Florida?
I stay there sometimes.
Thank you.
I also spent most of July in Nevada, but I don't live there.
Any more questions?
I have one more question. For the 204 Candy Court, part of that property is rented?
And that's going to affect the home exemption. I'm going to find out how that affects it. I don't know that yet.
Thank you.
Questions?
I guess I had one question because he said sometimes he stay in Yulee. Could you, about what percentage of the time would you say that you reside?
I don't think I have to answer that question because unless my wife asked me that.
Ms. Beadle, you're allowed to rebuttal if you would like. Please come up to the microphone.
All I can say is if I was allowed to go back and just knock on the door, I wasn't trespassing. I knocked on the door and asked if Mr. Burnham lived here, and I left directly when I was told to leave. And I would have gone back to find out more if he lived there on another day or something, but after the man followed me, I did not want to go back there. And I just thought I had my evidence by them telling me to get off the property and not ask questions, and the lady said she lived there. So that is all. She didn't say Mr. Burnham lived here. She said I live here. So that's all I can say.
Yes, sir, go ahead. If it's relevant to the public hearing.
The second time Ms. Butel went to our house, she did not knock on the door. She fiddled with the lock because there was no cars in the driveway.
Sir,
Yes,
let's,
I think it is relevant. I think
relevant of whether you're a resident of Camden County? No,
relevant to what she did.
we're not here for that, sir. We're here to determine whether you're a resident of Camden County or not. Anything else? Anyone else? All right, the hearing is adjourned. Reconvene the special called meeting. New business discussion concerning elector challenge of James H. Burnham to remain on the Camden County electors list. Do I have a motion to accept or reject the challenge? I will make a motion to reject the challenge. So is there a second? Motion fails. All right, we have two choices. We can either adjudicate this today or we have to have a continuance.
I move to have a continuance.
Okay, when would you like this continuance? All right. It's been moved to second. We have continuance. We do have this Thursday at 4 p.m. available. Yes, we will have to approve that. I'm just trying to clarify when we will be able to do a continuance.
Can we do it at board meeting? Schedule for those.
Yes, that's what I was planning on doing.
I'd like to do that.
All those in favor of a continuance till October 19th at 4 p.m., say aye.
Aye.
Opposed? Motion carries.
Yeah.
There being no amendments or corrections, the agenda is adopted as presented. Any public comments on the agenda items? All right. Seeing no comments, the regular meeting is adjourned and we're going to convene the public hearing. The Camden County Board of Election Registration hearing continuation is called to order. All members are present. I see the challenger and the challenged voter are here. Before we begin, I need to apologize to both the challenger and the challenged voter, along with my fellow board members and election staff. I did not perform the in-depth research that would have been required for this challenge. I failed to prepare the board with vital information, such as judicial decisions, attorney general opinions. I failed both the challenger and the challenged. This vital information was contained in the code book that I look at every day. I looked at the applicable codes. I read them completely understanding the legislative branch crafted the words. Where I erred was not taking into consideration the judicial branch, which actually tested these laws. And that's what we're going to talk about here in a little bit. I'm going to ask the IT representative to bring up the board document. And as we go through these, if you have any questions, please stop so we can get them answered. All right, the first thing we had was a homestead exemption. There was a question about if a house is partially rented and the owner still lives in the house. Can it be a homestead exemption? You'll bring it up a little bit. This is the opinion of the Attorney General. It says exemption when a house is occupied partially by owner and partially by tenant. Person who is the person's family occupies a portion of the person's house as a dwelling may receive a homestead exemption, although remainder is occupied by the person's tenants. Okay, so that answers that question. All right, there was a little known case in 1997. There was a mayor's race in Midway, Georgia, and the two candidates, one was within probably about 8 or 10 votes of the other one. The loser decided he wanted to challenge some voters, and he did so. They came before the Supreme Court of Georgia, and this is what they decided. Two of the voters challenged on residency grounds were Howard Freeman and his wife Carolyn Freeman. Their testimony showed that Mr. Freeman grew up in Midway, entered the military, and all of his relatives still live in Midway. When Mr. Freeman retired from the military in 1993, they voted in 1997. He retired in 93. He should have updated his residency at that point when he retired. The Freemans had a house in Hinesville, but always considered Midway to be their home. Mr. Freeman worked for the city of Midway, and they were regularly traveled back and forth between the two cities. The Freemans attended church in Midway and had a trailer there, which they sold 2 or 3 years ago prior to the election. After the sale of the trailer, they would stay in Midway with the Freeman's mother. Mr. Freeman apparently still owns real property in Midway and is in Midway almost every day. Mrs. Freeman's bank account is in Midway, and she has voted in Midway for 16 years. The Freemans expressed intent to keep their house in Hinesville temporarily and to return to Midway permanently. Finding the fact regarding voter residency shall not be set aside unless clearly erroneous, and due regard shall be given to the opportunity of the trial court to judge the credibility of the witness. The evidence authorized the trial court's finding that both Mr. and Mrs. Freeman were qualified to vote in the city of Midway. All right, the other thing we're going to talk about is length of stay away from a domicile is immaterial. When an individual travels away from the individual's domicile for a time, it is immaterial, whether such a stay is for 1 month or any number of months, provided it does not become so extended that it can be reasonably inferred that there is an actual intention to make a change in domicile. The last thing is domicile. Prerequisites for change. For a person to change a person's domicile, and domicile and residency are synonymous. It is essential for that person that person should have a bona fide intent to make the change. In addition, the person must also declare an intent to change the person's domicile and to do some act in execution of such intent. That's what the law says. Is there any questions? All right, we'll move on. All right, we're going to go through the process of continuation. And per the Georgia Rules and Regulations, Rule 295-11-02, Mrs. Buell and Mr. Burnham, you're reminded that you're both still under oath. Do you have any additional witnesses from either side? Okay. Reminder, per 21-229, the burden shall be on the elector making the challenge to prove that the person being challenged is not qualified to remain on the electors list. In order of presentation, the challenger shall present any additional information. The challenged shall be allowed to cross-examine, and the board will cross-examine also. Mr. Burnham, you're not required to prove anything at this session. It is all on your challenger to prove that. And you're not compelled to speak or provide any evidence from here on. Any questions? All right, we'll call out the first witness. Ms. Buell.
Sir, I really have no other evidence to present. The only thing is, my only evidence is my common sense with dealing with this and what I read, what I heard, and that my common sense tells me that Mr. Burnham lives in Yulee and that he doesn't live with his renters in St. Mary's. But I have nothing further to go on that. And I just would like to thank you all for this hearing, for coming back and listen to me. And I know whatever decision you make, I totally respect it and thank you all.
Mr. Burnham, do you have any questions? Cross-examination? Nothing? The board have any questions? No questions? All right, Mr. Burnham, do you plan on making a statement or anything?
Just that
You're not required to, by the way.
the only statement I had was the one I made the other day, that I have always considered myself to be a Camden County resident and continue to be so. I pay my taxes in Georgia, but I don't know what else to tell you.
Board, do you have any questions? Specifically rated for this? All right. All right, seeing there's nothing else, hearing is adjourned. Reconvening the regular board meeting. All right, unfinished business. Discussion concerning elector challenge of James H. Burnham to remain on the Camden County electors list. Do I have a motion to accept or reject the challenge?
Motion to reject the challenge.
Do I have a second? I'll second that motion. Any discussion? All those in favor, say aye. Aye. Opposed? Pardon? Yeah. Motion is denied. Do I have a motion to accept the challenge?
I'll make a motion to accept the challenge.
Do I have a second?
I'll second.
Any discussion? All right, I have discussion. I just showed you what the Supreme Court of Georgia said about a person that did not even live in Midway, Georgia, was allowed to vote in, they lived in Hinesville, voted in Midway, and the Supreme Court said because their intention outweighed where they lived. If we go ahead and accept this challenge and it gets to the Superior Court, it will be overturned. I have no doubt in my mind. All right, any other further discussion? All those in favor of accepting this challenge, say, or raise your hand. All those opposed? You got 2 hands or 3? How many hands we have? 2 hands. All those opposed? Pardon? Okay, so we have 3. All right, all those opposed? Motion to reject is made. All right. I have a couple of comments to accept the challenge. So right now you will be removed from the voters list of Camden County at this point. You do have some recourse. All right, it says if the Board of Election and Registration uphold the challenge, the person's application for registration shall be rejected, or the person's name removed from the list of electors as appropriate. The elector shall be notified of such decision in writing, either by first-class mail addressed to the mailing address shown in the person's voter registration records, or in the matter provided in. In other words, we can subpoena you. Either party shall have the right to appeal from the decision of the Board of Election and Registration to the Superior Court by filing a petition with the clerk of the Superior Court within 10 days after the date of the decision of the Board of Election and Registration. A copy of such petition shall be served upon the other parties and the Board of Election and Registration, unless and until the decision of the Board of Election and Registration is reversed by the court. The decision of the Board of Election and Registration shall stand. Do you have a question, sir? 10 days after this decision, it has to be filed. And it doesn't say 10 business days, it says 10 days. Okay. Pardon? Yes, yes. You'll have a copy probably by Monday of our decision, so that you can file whatever paperwork you need to file. Okay. Any additional public comments? All right. If there's no objection, this meeting will adjourn. Seeing no objection, this meeting is adjourned. Discussion to rescind the vote decision made during the October 19th regular Board of Election and Registration meeting to accept the challenge made by Margaret A. Butel of James H. Burnham to remain on the Camden County list of electors. I'll make a motion. I move to rescind the motion made during the October 19th regular Board of Election and Registration meeting to accept the challenge made by Margaret A. Butel of James H. Burnham to remain on the Camden County list of electors and expunge this motion from the minutes of the October 19th regular Board of Election meeting. Do I have a second?
Second.
It's been seconded. Any discussion? I do have a little bit of discussion. If you'll look at the screen up there, we're going to talk about irrebuttable presumption of a married woman's residence is unconstitutional. So back in 1920, Amendment 19 to the Constitution was ratified. It not only gave women the right to vote, it gave all sexes the right to vote. So it was not exclusively just for married women or married men. It was for everybody. So when we talk about irrefutable presumption, is a legal inference or assumption that the facts exist, which cannot be overcome by any additional evidence or argument. Basically, it's settled law. So in 1933, Georgia decided that they were going to use this irrefutable presumption and make women register to vote wherever their husband lived. They had no choice. And no one could argue it because they used settled presumption. Until 1973. So it was ratified in 1920. It took 53 years for it to come up before the Northern District of Georgia. And the court said they granted plaintiff a temporary restraining order to permit her to register and vote in the November 6, 1973 election in Albany, Georgia, notwithstanding the fact the plaintiff's husband claimed a domicile and voted in the state of New Jersey. She won that case. And now women and men do not have to register to vote in the same residence or domicile that their spouse lives in. All right, example of facts that were dismissed during the hearing. Mr. Burnham's name being on the deed at 204 Candy Court. Homestead exemption application for 204 Candy Court. And his under oath statements and various judicial decisions and Georgia codes. We went on the don't confuse me with the facts, my mind is made up. And we probably violated your constitutional rights, sir, by doing that. Your 19th Amendment constitutional right. So today I ask you, do the legal thing and vote to rescind this motion and expunge it from the record. That is all. Anyone else? All right, we're going to do a voice vote. We're going to start with District 4, yay or nay?
Yay.
District 3.
Yay.
District 2.
Yay.
District 1.
Yay.
All right, motion carries. The motion has been rescinded. Moving on to unfinished business. Discussion concerning the challenge made by Margaret A. Butel of James H. Burnham to remain on the Camden County list of electors. I move we accept Margaret A. Butel's official withdrawal of the challenge of James H. Burnham to remain on the Camden County list of voters and fully restore his name on the Camden County list of electors. Do I have a second?
Second.
So moved and seconded in discussion. All right, we're going to do a voice vote. District 1, yay or nay?
No.
Pardon?
I'm sorry. We are doing what?
We're going to accept the challenge withdrawal.
Yes.
And restore his name onto the Camden
Yeah.
County. Yay? District 2?
Yay.
District 3?
Yay.
District 4?
Yay.
Motion carries. Additional public comments? Please state your name and address.
My name is James H. Burnham. My address is 204 Candy Court. And I wanted to thank you, Mr. Rapp, for conducting a very good meeting and also for doing a lot of background research and presenting it. And for each member on this board, I'd like to thank you for your time for serving on this board, but I'd like to remind you that when you're on an official board, just as when I was a poll manager, I may have been the most rabid Republican you ever met. When I was on that board, from the time I picked up my box until I returned everything, I put all personal agendas and political agendas aside, and I followed the law. And I would like for all of you to do that same in the future. Thank you.
Thank you. I found it funny, actually, that you mentioned that you don't have someone for the board for voting, especially since you just turned down someone. You actually turned down 2 of Commissioner Smith's appointees. Dr. Gray, I think you turned it out because she's challenged you before. And I was hoping the voting block would be changed by Mr. Cheek being up there, but it hasn't seemed to be that way. And in fact, I hope you all look at the video. Twice during the vote, before voting, you'll see him look at the commissioner, see how he's going to vote. Just keep that in mind. Thank you. Oh, by the way, it's been over 25 years before a nominee's been turned down.
Donna Schwartz. I'm in District 4. I'd just like to say that not electing somebody to the Board of Elections that's already been on there and has been trained, the taxpayers paid for that, and we don't want to have to pay it again. So we'd appreciate it if you'd go ahead and appoint someone. Thank you.
Thank you.
Good evening, Dawn Gray. So clearly, I'm not the choice of three of you, but I will tell you this, that I know that election code well enough to know that the enabling legislation for Camden County is pretty specific, as are the bylaws for the Board of Elections for here. 5.2 specifies if it is not done within the 30 days, that it goes to, to the probate judge. So I may not be your choice, but I do recognize what both the enabling legislation under HB 1032 says, as well as the bylaws that are pulled from that enabling legislation. The only way to not be in violation is for it, in fact, to go to the probate judge.
All right, we can, since there's so much angst about the elections board, I'll make a motion, we appoint the person that's already there. I second that.
Thought this was District 3's appointment. Is that how you go run stuff?
You don't have the floor, sir. Any discussion?
Yes, I have discussion, since we're opening it up to discussion. The current District 3 appointee to the Board of Elections they had a hearing in front of them where they were discussing whether they were going to take away someone's right to vote that lives in District 3. Even after being told by the chairman of the election board that any action taken there would be overturned if it were to go to court, she still voted to take that gentleman's right to vote away. Subsequently, they had a meeting 2 or 3 weeks later where they, again, it was for the purpose of the gentleman's right to vote, to reinstate it. She again voted to not reinstate his right to vote. And that's why I cannot, in good conscience, appoint her back to the Board of Elections.
All right, well, we got a first and a second. All in favor? Those opposed? All right.